All right. Good afternoon, everyone. Thank you for joining us today. I have the pleasure of joining in with some of the best of the ADR in Georgia, Mr. Shelby Gilbert, Scott Zucker, Stephen McKinney, Ms. Stacy Hornsby, as well as Ms. Tracy Johnson. At this point, I want to have everyone introduce themselves. Again, this is, just to be sure, sponsored by the State Bar of Georgia's Dispute Resolution Section. I'm Sasan Nemabakhsh. I'm an attorney at law and mediator, as well as arbitrator. I'm based in Atlanta, Georgia, and I practice with the Matt Law Firm. And I have the honor and pleasure of being the chair of the Dispute Resolution Section. So without further ado, Stacey, please go ahead, tell us more about yourself and introduce yourself to the audience.
Sure. Thank you, Sasan. Hello, everybody, and thank you for joining us today. I am Stacy Hornsby. I am the past chair of the Dispute Resolution Section for the State Bar of Georgia. I am also the director of the Lemon Law Administration for the State Attorney General's Office, as well as an adjunct professor at both UGA Law and John Marshall Law School.
Thank you, Stacy. Tracy, please go ahead.
Thank you, Sasan. I am Tracy Johnson. I am the Executive Director for the Georgia Office of Dispute Resolution. I have been a registered mediator since 1996 and have spent most of my career as a program director for the 6th District ADR program before I went to the Family Division in Fulton County Superior Court right before coming here. So it is a pleasure to be with you, and thank you for putting this on, Sasan.
Thank you for joining us, Tracy. Steve, please go ahead.
Sasan, thank you for having me today. My name is Steve McKinney, and I am the immediate past chair of the Dispute Resolution Section. I'm the Managing Director of Dispute Management Services, LLC, based in Atlanta, which is an arbitration mediation service. I'm a certified arbitrator and mediator, and my primary vocation is as Chief Legal Officer of the Klotz Group of Companies in Atlantic Beach, Florida.
Thank you, Steve. Shelby, please go ahead.
Hi, Sasan. Thanks for organizing this panel today. I'm Shelby Gilbert. I am a partner at McGuire Woods in the Complex Commercial Litigation Group, where I specialize in insurance recovery and in cross-border litigation and arbitration. And I am also the president-elect of the Atlanta International Arbitration Society.
Thank you for joining us, Shelby. And Scott, last but not least, please go ahead.
Hey, good morning, everybody. I'm Scott Zucker. I'm an attorney at Weissman and Zucker here in Atlanta and director of Epic Mediations, and also now the section chair for the Atlanta Bar Association Dispute Resolution Section. And glad to join you today and excited to join in on this conversation on an important topic.
Thank you, Scott. So let's begin. Tracy, if you we had a session in August, and it was more of an overview of the UMA. For the folks that missed that session, and just for to begin the conversation, would you please give us an overview of the UMA? When we talk about UMA, what are some of the differences that, with regards to ADR rules that exist in the past, we're talking about some of the definitions that have changed? Please give us a little bit of overview.
Sure, I'm happy to. And I'm not going to spend a ton of time on this. We have a lot of meat to get to, a lot of substantive matters. We've got a lot of experts on this call. So I just want to say, to begin with, it takes a village to raise a child. Well, it took a village to get this passed. It took a lot of people, and a lot of people on this call, a lot of people on the webinar. And so I just want to always say thank you, because it still seems a little surreal that we're here. But the GUMA is applicable to all cases, both private, those occurring outside of the court, and those court ordered. And when I say court ordered, it's court connected, court annexed, court mandated. They're all interchangeable. But it means that there's an order in the case to mediate, and that includes standing orders. Before the GUMA, the only set of rules that we had were the Supreme Court ADR rules that governed confidentiality. There were protections for those cases in court. We have disclosure requirements, we have ethical standards, but there really wasn't anything out there for the private cases. Now the UMA, like I said, covers all cases, but there are some exceptions. Collective bargaining disputes, certain judicial conferences where a judge may make a subsequent ruling in a case, peer mediation for those students who are mediating in the schools, and then mediation in correctional institutes. So those are exempted from the Georgia Uniform Mediation Act, or some of them. Now, the Supreme Court Commission on Dispute Resolution was in support of this from the very beginning and took a lot of measures to make sure that the UMA, as when passed, did not conflict with the Supreme Court rules. We did a lot of research, a lot of work, but we didn't want to make a lot of changes to it for the sake of uniformity. We felt that the passage of the UMA in Georgia would promote predictability and simplicity and encourage the greater use of mediation. So we didn't want to make too many changes. There are some differences in terminology, some things, especially the terms privilege and confidentiality used in both of them, a little different, but we see the Georgia Uniform Mediation Act it complements the Supreme Court rules. The Supreme Court rules have additional things in them that aren't covered by the GUMA, like the approval of court programs and under the Georgia Court Connected ADR Act, the creation of the commission, its governance, this office, obviously, the creation of the Registry of Neutrals, the establishment of qualification and trainings. But we still wanted to make sure that there wasn't any confusion between the two. So once the UMA passed, once it was signed into law, then the commission put together a special committee. Some members are on this panel today, and we're looking at the rules and looking at the Georgia Uniform Mediation Act to make sure that there's not any confusion. So what we're doing is the committee is charged with possibly making recommendations for some tweaking for terminology. And then what they'll do is they'll bring that back to the commission, and we may end up, making some changes to the rules, but I think it will strengthen our rules and obviously bring them more in harmony with the GUMA.
Thank you, Tracy. It sounds like there's been a lot of work that's been done over the course of past couple of years, and some more work to be done to make sure the implementation goes about right. So Scott, Tracy mentioned confidentiality. Let's get to it, because that was also a topic that we discussed last time around. So as you know, Section 408 of Georgia Code, the Evidentiary Code, has certain measures in place for offering compromises as well as settlement conversations. Tell us more about why we needed UMA. What are some of the protections that exist before this in the Georgia Code, and just what happens now with this additional protections?
Well, I followed the roadmap that Tracy's established in some of her writings on this, and I think if you focus in on the confidentiality issue as just one of the focus items of the benefit of the UMA, it's really an interesting study relative to, from a litigation perspective. So my practice of litigation and mediation is a part of that. So I've really seen already the consideration of how the UMA focuses on evidentiary issues and protections relative to confidentiality. So we all know that Rule 408 is an evidentiary rule that applies to the admissibility of that information, and to the extent that it's been a method of protecting information derived from settlement conversations and mediations in the past for evidence purposes. But there's been plenty of loopholes dealing with issues arising from discovery and trying to get information from a mediation or the mediation process as part of a discovery effort. And I think there's been questions whether Rule 408 would apply to protect people from that issue of the confidentiality. And there's been other issues, loopholes dealing with bias or prejudice of a witness and how the negotiations have happened. So I think one thing the UMA does that I think is great is clarify that it protects the confidentiality of the process in all areas, including discovery, including admissibility at trial. And then also the big piece for me, which I think is very helpful from now my hat as a mediator, is it protects non-parties with respect to requests for information arising from the discovery process for admissibility and as evidence. So a non-party under the UMA has the right to protect himself from the confidentiality of the requests concerning the mediation process. So now a mediator is protected, a non-party is protected relative to the request for information arising from the mediation process. And I think if we all sort of sit back and look at the whole goal of this, and I'm not one of the wonderful people that work so hard to make this happen. I'm just jumping on the bandwagon now for the benefit of what you all have done. But I could see now how mediation will be enhanced in our state. And I know Shelby will talk about this even internationally, based upon the fact that we've heightened these rules of protection regarding confidentiality. If there was any anxiety for people out there before about participating in the mediation process, was maybe that risk of confidentiality being lost at somewhere during that process. And I think the UMA does an incredible job of sort of filling in those loopholes, those gaps of anxiety about confidentiality and protecting the mediator and the parties and witnesses to the process.
Thank you, Scott. Sounds like the UMA has done a more comprehensive job of protecting everybody as well as the third-party mediators. So Stacy, as you teach in law schools, and you're one of the first mediators I met when I actually became a mediator back in 2014. So you, I think, were one of the folks that taught me about the importance of mediation agreements. Tell us more how the mediation agreements play into Georgia Code, the UMA, the ADR rules, and just generally, the enforcement of these agreements.
All right, let me unmute myself first. That would be a great first step. Sasan, thank you so much for turning it over to me here. First, I really want to say that it's a common belief that settlement agreements that result from a mediation have a higher rate of compliance just because of the nature of how they're crafted. The parties themselves have worked together with the assistance of a neutral mediator to develop a resolution that they collectively feel is fair, one that they each believe is that they're capable of and have the ability to perform, and that inherently significantly reduces the likelihoods of parties failing to fulfill obligations that are set forth in an agreement. But that being said, there's still the inevitability of litigation dealing with enforcement of settlement agreements that arise in a mediation or out of the failure of the parties to comply with their mediated agreements. And they arise from a number of reasons: for disagreements over interpretation of material terms, lack of requisite authority, impossibility of performance, allegations of coercion or party duress, claims of incompetence or incapacity or fraud or mistake, or simply a change of heart of one or more of the parties to a mediation. And as we all know, there is no single body of law that governs the enforcement of mediated settlement agreements, but the principal method for enforcement of a mediated agreement in most jurisdictions is to treat the settlement agreement as a contract, and the law, as well as the UMA, favors the settlement of disputes by agreements by the parties. So courts will usually enforce those settlement agreements absent any clear present evidence of some defect of some sort. So courts usually uphold the settlement terms of the agreement, and the agreement itself that arises from a mediation, as we all know, as part of the UMA, is admissible if it is a writing that is signed by the parties. So when we talked about, communication being privileged, of course, there's protections for the mediator themselves and the conversation during the course of the mediation. But the mediation written settlement agreement itself is exempt from that privilege. So that if there were to be litigation arising from an agreement, then that agreement that is signed by all the parties can be brought forth to be able to be admitted and disputed as a result of the mediation. But of course, we're talking about the mediated agreement is treated as a contract between the parties themselves. And they're enforced mostly under contract law, and the contract law defenses would apply.
Thank you for that comprehensive explanation of the mediation agreement. So I think one of the points that you mentioned last time, Steve, was inclusion of the UMA in the mediation agreement. But let's talk about more of just, let's get to the UMA itself. So before I ask you the question that I have for you, Steve, if you're just joining us, welcome. We are having a conversation that we've discussed so far, confidentiality as it relates to Section 408, as well as the mediation agreements and just an overview of the process. So Steve, help us understand some of the statutory privileges that now exist as a result of the UMA with regards to confidentiality.
Thanks, Hassan. Everybody would agree, I think, that at the heart of the mediation process is an ability of the parties to take part in a conversation led by a neutral that has the opportunity of creating transparency, giving them a position of safety from which they can evaluate their position, listen to an evaluation of one or more other positions, and be candid with the neutral about strengths and weaknesses in the position, or perhaps even share strengths and vulnerabilities of a position with an opposing party. All of that, if it is to work, and I would argue that mediation simply doesn't work without that kind of transparency. If all that is to work, you have to have some kind of legal underpinning, giving the participants in the process a sense that they're protected and that what they're sharing is being shared within the context of this process and will not leave the context of the process. What the UMA achieves is to provide the participants in the mediation, both the parties, anyone that they might invite to participate in the mediation that is a non-party, and significantly the neutral, him or herself, with the ability to operate in a sense of true confidence with one another, without a sense that they are going to be forced in any manner to disclose whatever is shared with them in the mediation context. The UMA describes mediation communications very broadly, not only to relate to things that are said, but things that are shared, documents and other information. There is a provision that I think is very important that even goes to creating an affirmative obligation, or rather an affirmative ability on the part of the neutral, not to give a report to the adjudicator, whether it's a judge or an arbitrator. That is to say that the statute impresses upon the neutral an obligation that they not make a report, even if it's requested from the adjudicating body. I think that's terribly important because even today, after mediation has become so ubiquitous and pretty well understood, I still have the rare occasion where a judge will reach out to me and ask me questions about what happened in the mediation. I suppose, based on sort of an ill-conceived notion that I'm going to help them decide who's wearing the black hat and who's wearing the white hat. And of course, I have had in each instance that I've encountered that to explain to the adjudicating officer that I won't do that. Now in the state of Georgia, I have a statute that affirmatively requires that I not respond to those inquiries. All of this taken together, Sasan, really creates a situation where the mediation process can work and can work effectively and can work with the confidence of everyone participating. I think that particularly with regard to parties who oftentimes come to Atlanta in particular to do what I would call a destination mediation, where Atlanta is the situs of the process simply because of logistical considerations or maybe the neutrality of the location. Parties from outside the state of Georgia, parties from other parts of the world are given greater confidence about coming to Atlanta and participating in the mediation process, because there is in fact a statutory privilege created, which I think is fundamentally different and fundamentally more workable and fundamentally more reliable than being left to craft an argument before a judge under Rule 408, or trying to protect your rights pursuant to a mediation agreement that was simply passed around a table, perhaps not even read, and signed on the day of the mediation. I think this fundamental competence, let's say for foreign parties or parties from other parts of the United States, gives them a sense that Atlanta is a place where they can come and do their mediation business in a way that's effective and enforceable.
Thank you, Steve. I appreciate that explanation of the confidentiality and the role that UMA plays in enhancing those confidentialities for our everyday practice. So I'm going to turn the table to you, Shelby. We've heard a lot about some of what's included. Would you please, and I think Tracy touched on it a little bit, with regards to the exceptions that exist to privileges and confidentiality in the UMA, would you tell us more about what's carved out? What are some of these exemptions and exceptions?
Sure, I'd be happy to do that. And then again, thank you for organizing this panel today. I think that before we go into the exceptions, it's first important to talk a little bit more about the privilege and who can claim the privilege in a mediation under Georgia's new Mediation Act. I think as Steve mentioned before, that before we had this act, I think parties who had a mediation may have been years later subjected, and I've had to deal with this in my practice before, where I've received a motion to compel or a subpoena for information that was shared in some collateral mediation where I was representing a party years earlier. And my initial reaction was, well, gee, of course, everything that is said in the mediation is confidential and there's a mediation privilege. And we looked at that and making those objections, it was actually quite challenging to find any support for the notion that there is any mediation privilege. There certainly was no statutory mediation privilege before we passed the UMA. As Steve mentioned, we have this great evidence code in Georgia, which was enhanced recently, which does have section 408 of the code, but that just protects the admissibility of a mediation communication in that particular proceeding. So it does not protect parties from the discoverability of what is actually said in a mediation, which is quite different and can be just as damaging to a party if something that they don't want to come out outside of the mediation, if it's disclosed. It could be just as damaging for business issues or for the next proceeding that comes along. So that was eye-opening for me about 10 years ago when I had to brief my first motion to compel seeking those communications. I said, well, surely in Georgia, what's said in mediation is privilege, and that's true in some states. It wasn't in Georgia until we got this statute passed. But going back to your question, I think the starting point on the exceptions is first to look at who can claim the privilege, and that's set forth in section 3 of the statute. And I think that there's a recognition here, and I think some of the enhanced protections that are important here recognize that that there was more than just a party to a mediation, and because you've got a mediator. Sometimes parties might bring an expert if it's a large business dispute. So you might have a damages expert or somebody else who attends the mediation. If it's a family law dispute, you might have a estranged spouse who might be in the mediation, or some other third party who is not the mediation party. But you still want all those people who are in the mediation to do, as Steve suggested, to be candid with the mediator and to disclose information that might facilitate a resolution, because that's how mediation works. So what the section 3 of the Mediation Act does is that it allows a mediation party to assert the privilege. So the mediation party just being one of the parties to the dispute that's being mediated. It also allows the mediators to assert a privilege as to mediation communications. And some of that is designed to protect mediators from disputes that might arise after the mediation, or also protects the mediator from having to disclose. And if they're on the receiving end of a subpoena with an aggressive litigant trying to figure out what was said in the mediation, they want to use it for purposes in some collateral proceeding on down the line, the mediator can now assert that there is a privilege, and that was not the case before this statute was passed. The Section 3 also allows those non-party participants from refusing to disclose information that was discussed in the mediation. So whether you're talking about the estranged spouse in a family law mediation or some other party in that type of dispute, or you're talking about a large business who's got an expert in that proceeding that has all the financials for a particular business and knows what's said, they too can assert the privilege. Now, there are limitations and there are well-crafted exceptions. And one thing that when we looked at what we wanted to do with Georgia law, we thought it was important to get a mediation privilege. That was important and something that we wanted to do here, but we also wanted to make sure that there wasn't going to be a whole lot of litigation on the back ends where parties were coming in and saying, well, you're over asserting the privilege, you're preventing the search for truth. There's some sort of evidence that needs to come out. So the Uniform Law Commission that promulgated the Uniform Mediation Act, on which Georgia's Act is based, thought of these issues about 19 years ago when they came up with the statute. And they came up with some, I think, fairly well thought out exceptions to the privilege. And one thing that we noted when we researched whether this was a good statute for Georgia is that there hasn't been a lot of litigation in those states that have enacted the Uniform Mediation Act about these exceptions, where parties have come in and said, well, we think that there should be an exception to the privilege. I think the privilege and the privilege exceptions are quite clear, and they're laid out in Section 5. And I think that the exceptions that you see in Section 5 of the Mediation Act are really common sense. There are exceptions to the privilege if everyone agrees in advance that the mediation will not be privileged. So that was one thing that came up in the when we were trying to get the statute passed. Are there exceptions and can parties opt out? Well, yes, you can, but there's got to be an agreement evidenced by a record assigned by all parties. There are other common sense exceptions that, for example, if there's a threat in the mediation to inflict bodily harm or to commit a criminal act, that's not privileged. So there's a clearly crafted exception to that. Or if people are intentionally using communications within the mediation to inflict, to commit some other criminal act in the future or to support some sort of ongoing criminal activity, there is an exception. There's also an exception to communications that are protected under Georgia's Open Records Act, or the other types of communications that are already by public policy required to be disclosed. There is an exception as well if a communication is needed that the mediator asserts its privilege, but it's sought to prove or to disprove that a mediator engaged in some sort of professional misconduct or that a lawyer engaged in some sort of professional misconduct. There's a narrow exception that would allow those types of communications to come in. And there are also exceptions for communications related to abuse of children and exploitation of children, and references in the Act to the Division of Family and Children's Services mediation program, which is a little bit different, and wanted to be very clear that there are certain categories where it doesn't make sense from a public policy perspective to shield everything that's said in the mediation. But again, I think those are well set out in the statute and very easy to apply.
Thank you, Shelby, for that thorough explanation. So, Steve, Shelby's mentioned some of the party protections that exist. What does UMA do with regards to conflict of interest? And before you answer that, with regards to conflict of interest, I see that there's some questions coming in. Please go ahead and submit your questions. We're going to have a Q&A towards the end, and we're going to address all the questions. So, Steve, please tell us more about party protections and conflict of interest and how UMA deals with that.
You know, Sasan, the last answer I gave, I sort of backed up to first principles related to mediation and talking about confidentiality and creating an atmosphere of transparency that underlies the ability of mediation to work. There is another fundamental principle that the UMA addresses, and that is that mediation is even though there are court-sponsored programs, mediation is fundamentally about putting private parties back in control of their disputes so that they can take charge of and take responsibility for crafting resolutions of all or part of those disputes. It is so easy to lose track of that fundamental principle because mediation has become so ubiquitous and the process of mediation has become so routinized that in some ways we've all experienced parties marching into a room, quote unquote, participating in a mediation when it looks for all the world like this is just one more thing being done to them, and they're just spectators and watching it happen. Fundamentally, the UMA provides some really important prompts, both for the parties and for the neutrals, to get back to this first principle of the parties being given an opportunity to take charge of and responsibility for their dispute. One of those is that an affirmative obligation is created on the part of the neutral to disclose potential conflicts of interest, just like you would in any situation that you might have as a lawyer. You'd like to think that a good neutral would do this anyway, but the UMA creates an affirmative obligation for the neutral to disclose, and not just to the lawyers or those assisting in an advocacy role, the parties in the mediation, but to the parties themselves, potential conflicts, and not just conflicts like you would think of in the terms of the Code of Professional Responsibility, but anything that would bear upon the neutrality of the neutral and the neutral's ability to be even-handed and fair needs to be disclosed. And I think primary among those kinds of disclosures is how often the neutral has worked with the advocates who are participating in the mediation process with the parties. I think parties go into mediations all the time, completely blind to, or at least not being made aware that the neutral has worked perhaps hundreds of times with one or more of the lawyers or advocates who are there. I think that's terribly important to a party to try to get a sense of whether or not there is a personal relationship. And I'm really not talking about anything deeply unethical or someone trying to be unfair, but this is the party's process. This is the party's dispute. The dispute doesn't belong to the neutral or the lawyers. So I think the UMA does a splendid job of creating that affirmative obligation on the part of the neutral that has the effect of driving some information in the direction of the parties that they can use in helping to select who the neutral is going to be. Another of those affirmative obligations created on the part of the neutral is to make their credentials, to make their experience and their expertise related to the particular subject of this particular dispute available to the parties, so that there is some prompt and nudging on the part of the parties to actually do some selecting, not just relying on who their lawyer knows or has worked with, but actually trying to see if the neutral fits the dispute and is in a peculiarly helpful position to be helpful to the parties themselves. And the third thing I'd observe is that there is in the UMA a prompt, or at least an acknowledgement, that neutrals, those who are serving as mediators, do not have to be lawyers. They don't have to have law degrees. They don't have to be a member of the bar. I think it's terribly important, again, from the standpoint of having the parties understand that this process, although they may ultimately think as a practical matter it would be a good idea for the neutral to be a lawyer, to have an understanding that the process itself isn't underwritten by the neutral's lawyerness, but is underwritten by the neutral's ability and the party's sense of the neutral's ability to help. I've made reference in these seminars several times in the last several weeks to having two parties that I've worked with in the mediation setting who happened to be Iranian Americans, and they happened to be Orthodox Jewish Iranian Americans and came from a very close-knit community, an expat community here in the States. And they brought into the mediation a very closely negotiated mediation agreement or settlement agreement that they had worked on with a rabbi. And it was very clear to me reading through that in preparation for the mediation session I was going to do with them, that what they had done in working with that rabbi was every bit as much a mediation as anything I had ever done, because they were working around trying to take responsibility for and craft a resolution to a dispute. So anyway, I think the UMA does a very good job of driving the parties in the direction of taking responsibility for crafting the dispute and getting the dispute back in their hands.
Thank you, Steve. I appreciate that thorough explanation of some of these party protections that exist. So, Stacy, you've been very patient, and I want to bring you back to the conversation. So, when you're talking about these confidentialities, party protections with regards to conflict of interest, are there any important considerations that you think we haven't discussed so far?
Well, I think also we talked about in my segment about the settlement agreement itself, but also there is the agreement to mediate that precipitates the mediation process. And that agreement, a lot of, if you look at a lot of the court connected mediations, in that agreement to mediate that is signed not only by the mediator, but is signed by the parties, as well as anyone that is, not a minor that will be a part of the mediation process. It delineates things like confidentiality. It talks about the voluntary nature of mediation. It tells, in some instances, what the mediator's job is. It covers those exceptions to confidentiality. So on the front end, before a mediation ever begins, some private mediators may send those agreements to mediate out to the party so that they've had an opportunity to review those pieces of the puzzle, because there, it may be a misperception, but everybody has not been a party to a mediation before. They may not know, what to expect during a mediation. They may not know what confidentiality means and, what those exceptions are. And so having that information right up front before the parties ever enter into the mediation process, and they're each signing to that, as well as the mediator signing to that, and they understand what the expectations are of them, and they understand what the protections are of the process. And it kind of lets that wall down for the parties to understand that they can share information knowing that, they have that protection and they have that privilege on the front end.
Thank you, Stacy. Scott, I'm going to come back to you. So a lot has been discussed with the party protections, confidentiality, mediation agreements, the rules that existed in the books before. My question for you is on the day-to-day practice of mediation. Lots of responsibility is placed on the mediators. How does all of what we're discussing, party protection, confidentiality, everything, changes the practice of mediation?
Well, I'm going to give kudos to Steve for this. He mentioned this on an earlier program that we all did, and we really haven't thought about the practical aspect of all this, is go back and look at the mediation agreement that you're using in your business as a mediator and update it. And I give credit to Steve for the clear practical application of, we're also busy with our practices to understand that needs to be updated based upon the enforceability now of the UMA to address these issues that Stacy's talking about. So I think the number one thing is really for us to remember that it is our obligation to now update our documents relative to the passage of the law and to consider those elements of the law now in the operation of our mediation practices. I'd also say that it goes back to Tracy and the work of the Office of Dispute Resolution, and goes again with what Steve was talking about as non-lawyers being mediators, is I think that the criteria of being a appropriate mediator for the resolution would require you to be certified through the office that Tracy runs. And I think it then behooves the folks out there that want to be mediators that haven't yet been certified, but in private mediations have been able to do it because they're not governed under the court-ordered aspect of mediation, that they really, for the benefit of their the parties that they work with to help them resolve their disputes, if they be qualified and should be certified through the office that Tracy runs. So I think it all sort of comes together with respect to what we're trying to make sure folks are thinking about now is I'd like to say a new sheriff's in town a little bit with respect to the way that we need to operate our mediations under new documents and new perspectives and sort of new rules. And I think everyone will benefit from that. Not only the mediators ourselves with respect to feeling more protected, but the parties, just going back to what Shelby and Steve said, you know, the integrity of the process, the impartiality of the process, I think it will benefit everybody.
Thank you, Scott. Very helpful. So Tracy, I think it's a good segue for you to also help us understand some of the special qualifications that now exist to be a mediator. Can, as Steve was mentioning, can a rabbi now mediate a case? Can a priest mediate a case? Tell us more about some of the special qualifications that UMA imposes on the role of the mediator.
Sure, happy to. And yeah, this just segues right from Scott's conversation. You know, for nearly 3 decades, the Supreme Court ADR rules have been very specific in training and qualifications of neutrals based on case categories. So they've had rules in place. You had to be registered. Under this law, though, mediators defined as an individual who conducts a mediation with no restrictions. So that's in private cases. However, this was one definition that we asked the commission wanted to make sure was clear that if it is court connected, the individual must be registered pursuant to the Supreme Court ADR rules. And a lot of this goes to quality. You know, in court connected cases, you have a lot of self-represented litigants. As Stacy said, a lot of people, this is their first time, but they're not even represented by counsel. And you have mediators who also are not attorneys. So it was really important that for those cases, the way for us to be able to maintain quality in our courts, that we make sure that the mediators are trained, as Scott said, they have their credentials, are going through the right channels, are getting the continuing education, they're sharp in their skills. So it was very important. So for the private cases, there really are no restrictions, but for the court connected cases, it's very clear now you must be registered for those types of cases.
Thank you, Tracy. All right, so we've talked a lot about many aspects of it. One aspect that we haven't discussed about UMA, and I see the questions coming in. Appreciate you all sending in your questions. We're going to get to them in the next couple of minutes. So one aspect that we haven't discussed, Shelby, is the international component of the UMA. How does the business, world, the international business world, how can they find more comfort in bringing their disputes here or doing more business in Georgia? And you're on mute, Shelby.
Thank you, Sasan. I think that the section of the statute dealing with international mediations is the part that at least I'm most excited about, because it sets Georgia apart from any other state in the United States and shows that we're continuing to be on the leading edge of alternative dispute resolution, not only in the United States, but I think globally. And the reason I say that is that I think everybody on the call knows that Georgia has long been an important center for international business and trade, and that's in all parts of the states. It's not just Atlanta, because we've got the big airport and that's where a lot of the big companies are. You think about the trade coming in through Savannah and other parts of the state. Now, increasingly, that's how jobs are created, and it's important to our economy. And one thing that I think undergirds the growth of international trade over the last 20 years that I think sometimes flies under the radar is that Atlanta and Georgia, I think, have one of the most welcoming environments for the practice of international law, and that we've got bar rules that are friendly to foreign practitioners when they come in the state and need to do business and represent a client in a transaction, or even stand up in court. And they can be pro hoc into court and represent parties or say something in court. That's not true in most other states around the United States. I think another thing that sets us apart is that we have a great international arbitration code. I was part of a team that updated that code about 7 or 8 years ago. And we have a great international arbitration code, which signals a willingness to parties that want to arbitrate in Georgia, that we've got cutting edge arbitration practices where people can actually go to court if they need court assistance in aid of that arbitration. There's a process for doing that in Georgia, and it shows we're really open for business here for those types of disputes. Now, we were looking around as part of our Atlas or Atlanta International Arbitration Society group. We have a legislative committee as to what we could do to promote international mediation, because we're all doing international arbitrations, but half the time they resolve in the end through mediation. And some of us realize that mediation is big business, and that you have lots of parties, lots of people fly in for mediations, but a lot of times we were getting on planes and going and doing that in New York or other countries and going down to Miami to do it. And it seemed to us that, well, why is the bar losing those opportunities to resolve those disputes in Georgia, particularly when they involve parties that are litigating in Georgia or in Georgia businesses in some cases? And one of the answers that we got, and I think Steve touched on this earlier, is that before we had the Mediation Act, I would get questions sometimes, a lot of my colleagues would, well, and this was usually from an international party that would say, well, I hear you, we don't do mediation in this particular part of Africa or Asia. It's not a practice that we normally have. You're telling me that I should tell some third party that our case has these weaknesses, and that's part of the process to get the claim resolved? Sure seems to me that that could come out in discovery and hurt me later. And we try to assure them, well, we have these mediation agreements we can draw up, and the courts will enforce those agreements. And let's get the question, well, are you sure? Sure would feel better about it if there was a statute on the books that said that, and particularly for folks that were steeped in legal traditions from civil law jurisdictions, having a statute that they could look to and take back to their management was very important. So that was part of the reason we wanted to do this. But I think the other thing that we're really excited about that Georgia now has is that we've adopted what's called in Section 11 as part of our code, the UNCITRAL, which is a fancy abbreviation for United Nations Commission on International Trade Laws, model law for the enforcement of international mediated settlement agreements, which is something that the United States and a number of other countries were behind. And it's a model law that creates a mechanism for enforcing a settlement agreement produced by a mediation between parties from other countries. And that solves a problem. The problem was solved in the international arbitration field because there's a treaty that says in the New York Convention that if you arbitrate and you have an arbitration award, there's a mechanism now, a treaty mechanism that you can apply all around the world to enforce that arbitration agreement. But we don't really have that yet. It's coming in the mediation world, but Georgia now has a statute that tells you how to do it. And all of those other states that have passed either parts of the Uniform Mediation Act or all of it, they don't have that. And I think that sends a strong signal to the rest of the world that if you want to resolve an international dispute, it's safe to do that in Georgia. It's a good place to do it. And I think that also supports all of the companies that are thinking about, well, do I want to set up operations in Georgia, or do we want to do more trade in Georgia? That if there is a dispute, we have good mechanisms and good processes in place to support everyone to make sure that those disputes will be resolved fairly.
Thank you, Shelby. That's been very helpful. So we are, Steve, you've been, involved in the passage of this. Very briefly, before, in 1 minute or less, so we can move on to Q&A. Tell us about, the impact on international that Shelby has, so eloquently described. What do you think foresee happen with regards to? Do you think we can position Georgia as more of a center for ADR globally with passage of UMA?
I certainly think so. Certainly for all the reasons that Shelby just detailed, which are features of mediating with parties outside of Georgia and outside of the United States that I've personally experienced as a neutral here in Atlanta. It sounds like a sort of a Chamber of Commerce bromide to say that we've got a big airport and it's easy to get in and out of Atlanta. It's not a bromide. It is a very, very significant thing for parties who are involved in complex disputes to have places, and oftentimes to have places that are not Chicago or New York or London to get in and out of. quite frankly, Atlanta, as compared to most places where this kind of international dispute resolution has been done conventionally, among other things, is a heck of a lot cheaper. It just makes an awful lot of sense for Atlanta in particular. And I don't mean to slight the rest of Georgia, but it makes a lot of sense for Atlanta in particular to be prepared as a matter of law to host these kinds of events. Atlanta has had the level of sophistication in its bar association for generations to handle this kind of work. And it only makes sense that these kinds of opportunities ought to be available to those practitioners here in Atlanta, so that I know that, Shelby, you probably had situations where you and a bunch of Atlanta lawyers met each other at the Atlanta airport, flying together to some other crazy place to do what you could have done across the street. So I think those kinds of things are not lost on international disputing parties. And I think it is just a remarkably wonderful thing, not only that the Uniform Mediation Act has been adopted here in Georgia, but that it is the only state that has adopted the Uniform Mediation Act by incorporating the Untitled model law.
Thank you, Steve. All right, so let's move on to the Q&A, if you allow me. So there's a question that's come in. Does the statute apply if a Georgia mediator physically conducts a mediation outside of Georgia or conducts a Zoom mediation with all other parties participating from outside of Georgia? Great question. I see you are shaking your head, Stephen Scott. Shelby, Stacy, Tracy, please, who wants to take a first stab at this? Go for it, Steve.
I have the gift of creating patience in others. I would say, Sasan, that this again gets to, and I don't think anyone anticipated a pandemic would have this residual effect, but in the mediation context, it gets to the heart of the fact that the parties themselves are in control of this process. So the parties themselves decide what the rules are. The parties themselves decide quite improbably whether the UMA applies to their particular mediation or not. So I would simply make the simple observation that in the first instance, the neutral and the advocates who are helping the parties need the parties to understand that they can, by agreement, take advantage of the fact that the neutral is sitting in Georgia, or that one of the parties is sitting in Georgia, and adopt the Georgia version of the UMA, or not. But I think their ability to make those choices drives right at the heart of what mediation is all about.
Yeah, I saw Frank's question come in, and I thought it was great. It was definitely on our minds when we were trying to get this through the legislature last year, because I think most of us are doing mediations virtually or hybrid mediations where some folks are there, some folks aren't. And I think the question was, well, what application will Georgia's act have if folks are outside the state? And I think that one question we've seen pop up today is, well, how can we ensure that this act applies? Well, I think that one practice pointer is to do what Scott referenced earlier, to actually update your mediation agreements to reflect that you want it to be governed by the Georgia Mediation Act. That's one thing that you can do. Now, what happens if parties don't do that? I think that one thing that the Uniform Mediation Act is trying to do, and a number of other states have adopted it around the United States. I think by my last count, there are 12 or 13 other states that have adopted the act in largely the same form as Georgia without that international component. A number of other states have adopted parts of it. And I think that the whole idea of a uniform statute is to promote uniformity of practice around the country. And I think also, if you're trying to figure out which state's mediation act applies, I think if it's a court-connected mediation from the Georgia court system, then I think that strong indicia that the parties agreed that the mediation should be governed by the Georgia Mediation Act, even if the mediator that day happens to be in South Carolina sitting in front of a computer screen at the beach. So I think we'll have to see. And that's one of the exciting things I think about alternative dispute resolution today, is that we're all doing this in a different way than we used to, but it's a great opportunity for all of us, just given how backed up the courts are right now, to help provide a solution to the courts for cases just having, particularly on the civil side, are having a hard time moving through the system.
Thank you, Shelby. Scott, I'm going to point the next question to you. With regards to disclosures, what do you think are some of the best practices, and all other panelists as well, but I will start the question with you, Scott. What is the best practice with regards to explanation of some of the disclosures with regards to prior relationships and contacts with parties and attorneys?
I'm going to emulate, again, what Steve has talked about is transparency. I think it has sort of raised our consciousness to the importance of making sure that people feel comfortable in the process. And I have to laugh about the fact that for years before I started doing mediation, I would use 1 or 2 mediators exclusively. I mean, they were successful mediators. I felt comfortable with them. They end up getting to the result of what my clients needed ultimately, and the other side too. I mean, they just created resolution. And I was so impressed by that. I would just kind of go back to the well every time to the same mediators, but I don't recall ever really the mediator ever disclosing to the other side as a regular course, well, you know, I've had Scott in, 20 other mediations, and whether that really affected the other side in terms of the fairness or impartiality of the mediator. I don't think it did, because it's a mediation, nothing's binding. But I think it's so important to make those disclosures. So it's, it's clearly part of my practice now to really be very transparent about the relationship that I have with counsel that are representing the parties, make everybody aware of that experience that you've had. And if, we're all members of the bar, and you see a lot of the same lawyers and a lot of the same cases, so that you have to make sure that the other side feels comfortable that your relationship as a professional relationship doesn't impact the impartiality of the process. And I think your transparency in that issue helps to alleviate that concern. Now, you may not be selected because of that, and that's a risk that's sort of inherent in the disclosure process. I think it's also true that if you're not qualified to be a mediator in that particular area, and I separate that from the family law area where a lot of people just aren't registered to be family law mediators, they shouldn't be doing family law cases. You should sort of kind of stick in the lane that you're best prepared to help the other side, the other parties work out their resolution. So all that goes to answering your question. I think it behooves the obligation of the mediator now to think about these issues more front-facing, and to address it with the parties and the advocates.
I think, Sasan, that it's been natural for mediators that are in court-related programs that are for a specific type of court, like maybe landlord-tenant court or small claims court. They are going to see the same attorney representatives over and over again. And so, there's not that formalized process where in a private mediation, I can do my disclosures ahead of time. So I think that it's important that the mediators, when they're giving their opening statement, that they make those disclosures, that by the nature of being here in landlord-tenant court, I see, attorney X or Y or Z on a regular basis because they represent a number of businesses that are in this court, but that in no way makes me less impartial when it comes to your matter, and giving, just giving that clear and upfront to the parties, I think sometimes allays some of those fears or the perception of partiality or bias.
Thank you. If there are any other answers, please go ahead. If not, one last question in the interest of time and respecting everyone's time, since we're almost at 1. Have you all changed any part of your opening because of UMA, your opening statements? Go ahead, Steve.
I mean, I simply have used the adoption of the UMA as the occasion for driving home something that I probably wear out, I suppose, anyway, which is trying to help the parties understand that this process is their process. It's not about their lawyers. It's not about the neutral in the first instance. It's their process, and that they need to be actively engaged in it. and that the UMA is there to both highlight that and to facilitate that.
Thank you. And I recognize that there's some questions that we haven't got to, but we're almost at 1 o'clock. So if any of our panelists want to answer any of these questions, I strongly recommend you to just type them. But for the interest of time, please, if all of our panelists want to just quickly say one last word, and then we can conclude this session today. I want to first thank you everyone for joining us, and especially to our panelists for sharing all the great insight into the UMA and best practices when it comes down to mediation. So Shelby, please go ahead.
I'd just like to say thanks. I think we've got a really strong section here. You've got some past leaders of the section, and you've got Scott who leads the Atlanta section. And without them, I don't think we would have gotten this through the Bar Association. So kudos to them. And then also to Tracy Johnson, who kept our working group to get the statute organized. I know that she worked tirelessly and kept us focused, particularly during the pandemic, which was not easy to get this through the legislature. And then maybe a shout out to Mary Donovan, who I see is attending today. I think all the behind the scenes work that she did to make sure that we got this through was really instrumental, and it was a rewarding experience for me. I don't do legislative work, and it was a lot of fun, and I'm glad we made it to the finish line. So thank you.
Thank you, Shelby. Stacy, please go ahead.
Sure. I'd just like to echo that we thank you all for your interest and your participation. And we are all thankful that we have, a Supreme Court rules that are now complemented by the GUMA, and that it gives protections and an even playing field for those that are mediators through court-connected programs as well as private mediators. I think it puts us all on the same playing field. And so very, very thankful for that, and that Georgia is just a pioneer in that effort.
Thank you, Stacy. Steve, please go ahead.
I don't have a lot to add to what's been said, but I found it to be a very rewarding experience that private practitioners, academics like Stacy and others, folks who work for the state like Tracy, legislators, judges, all came together in a very creative, sustained effort. This took more than 3 years, and it's very difficult to sustain that kind of effort across that period of time with that many different kinds of players. And it was very inspiring, I found, to think that a good idea could be advanced by such a diverse collection of stakeholders.
Thank you, Steve. Scott, please go ahead.
I'll just echo everyone's comments. I mean, amazingly, to get a bill passed in the middle of a pandemic and to have such far-reaching impact to the practice of law and the support for the constituents of the state and internationally, it's just amazing. We just can't overlook how important this is. And I appreciate the opportunity to be part of the panel to again, educate folks about what the act is and how it should be used. So thank you.
Thank you, Scott. And Tracy, please go ahead. And Tracy is a rock star. She's been instrumental in so many different things. And please go ahead.
No, I'm just part of the process, and I, Steve and Stacy and Shelby all came down to the Capitol at moment's notice, many times to appear before different to appear at different meetings, the Senate and the House, but and Mary as well. I have to say, Mary Donovan was a driving force in this. But it just makes me so proud to be a part of this and to see this work. And as Shelby said, Georgia has been a leader in ADR, and this just continues us to be so prominent in the dispute resolution field for the nation. So I just really appreciate Sasan. I appreciate you putting this on and helping us get the word out. Scott did this last month, and just helping us be able to reach so many people and inform them and encourage them to read it. And if they have questions, reach out. I mean, I'm here at the office. I'm happy to field any answers. Feel free to give us a call. So thank you.
All right, ladies and gentlemen, thank you again for joining me. It's been a pleasure. I'm very humbled by the fact that I'm surrounded by such great legal minds and ADR experts. With that, please join us for our other events, our section members. And again, thank you for your time. Sorry that we're running 5 minutes beyond what we originally planned. Thank you.